Right, good morning, everybody, and welcome to those in the room and those joining us online to this Seven Kings Bench Walk seminar. I'm Rebecca Sabben-Clare. I'm one of the Silks in Chambers. To my right is Sir Julian Flaux, who has very recently retired from the bench and from his role as the Chancellor of the High Court, which we're delighted means that he's now rejoined us in Chambers, where he's practicing as an arbitrator. To Julian's right, Andrew Pearson, and at the extreme left, Michael Ryan. Michael and Andrew are both senior juniors in Chambers with very busy practices, much of which work is in arbitration or about arbitration. And then to my left is Alice Osman, who's just joined us as a junior tenant in Chambers, but is by no means a junior lawyer. Before coming to join us, she practiced as a solicitor in the International Arbitration Department of a US firm in London. So we're going to be talking today about Section 44 of the Arbitration Act as amended by the 2025 Act. I'm going to say a few words, just a very few words to introduce things, and then I'm going to be bringing in our panel speakers. Our plan is to allow enough time for some questions at the end. So if you've got any questions as we go along, please do store them up and we will try and take them at the end. Dotted around the room on the chairs, or at least some of them, there are copies of the Arbitration Act as amended. Those with long memories will recall that one of the central purposes of the 1996 Act was to restate the relationship between the courts and arbitration tribunals. And Section 44 has always been one of these sections which delineates the boundaries of that relationship. It has been quite substantially reworded, at least in places, by the 2025 Act. So in subsections 1 and 2, there remain statements of the broad powers vested in the court to make the same orders as the court would be able to do in support of legal proceedings in relation to those matters listed in subsection 2. So it's not a complete carte blanche. It has to be in relation to the matters listed there. Then 3, 4, and 4A restate the limits on the circumstances in which the court can act. Subsection 3 still contains the urgency requirement. And then in subsection 4 and 4A, there are new provisions that if the case is not one of urgency, the court may act only on the application of a party to the arbitral proceedings made with either the permission of the tribunal or the agreement in writing of the other parties. And subsection 4A, new provision that application under subsection 4 may be made only upon notice to the other parties and to the tribunal or the emergency arbitrator. The emergency arbitrator being a new species now recognised by the Arbitration Act and reflecting changes to many institutional rules. Then in subsection 5, we have still the provision that the court shall act only if the tribunal cannot, I simplify, again referring to emergency arbitrators. So we are going to be discussing how that section 44, has worked in practice and whether the changes will make a difference to the operation of the section. So I'm going to turn first to Julian. Julian, you gave the leading judgment in A and C in 2020, which was concerned with obtaining evidence in England in support of New York arbitration proceedings. So I'm going to ask you two questions rolled up together, if I may, which is, first, do you think that case sheds any light on the court's approach to Section 44 applications generally? And would the arguments have been different if the 2025 Act had been in force at the time?
Can I turn them around? Deal with them the other way around. The answer to the second point is obviously the decision. I don't think it would have even got to court because the words which are now in section 44, whether in relation to a party or any other person, would have precluded the argument, which was the principal argument, I'm going to address that a bit in a moment, that you couldn't make a section 44 order against a non-party. And to be honest, this particular amendment was one which was made on the recommendation of the Law Commission, because it was what can only be described as a bit of a dog's breakfast as a result of the case law as it stood, even after the decision in ANC. So in terms of whether ANC has made any difference to the law, I suspect the answer is no, because it's been overtaken by the amendment. But I'll talk a bit about that in a moment.
Yes. Okay.
Okay.
Right. Do you want to,
okay.
to carry on?
Yeah.
So at the time, the case has been overtaken by the amendment, but does it help us understand how the court might approach a section 44 application and the?
I think so. I'll talk about that a bit if that's the sensible course. Yes. Okay. Well, the starting point is really to recognise that the powers that are given by Section 44 are exercisable not only in respect of arbitrations where the seat of arbitration is in London, but where the seat is in another jurisdiction. And that's a consequence of Section 2, subsection 3 of the Act, that of the 1996 Act. And the only limitation under that subsection is that the court may refuse to exercise that power if the fact that the seat of the arbitration is outside England and Wales makes it inappropriate to do so. So there's a very broad discretion given to the court. And the issue that arose in ANC was where the seat of the arbitration was in another country, and whether the powers could be exercised against a non-party. There, as Rebecca said, there was a case, an arbitration proceeding in New York, where the appellant's claim was under two settlement agreements in respect of an exploitation and development of an oil field in Central Asia. And the appellants were entitled to a percentage of the net sale proceeds if the first and second respondents sold their respective interests in the oil field, which they did in 2002. And the central issue in the arbitration in New York was whether the sums which the first and second respondents paid to the government of the state where the oil field was located, which were described euphemistically as signature bonuses, fell to be deducted from the sale proceeds to be paid to the appellants, as was contended by the first and second respondents. But the appellant's case was that the payments were bribes, so they weren't deductible. And they relied on the fact that somebody who's only identified as G negotiated the payments on behalf of the local government and had been indicted pretty much 20 years previously, in about 2000, by a US court for violation of the US Foreign Corrupt Practices Act. And the third respondent, who was a resident in England, had been the lead negotiator for the respondents, and he'd negotiated directly with G. And what the appellants wanted to do was to call the third respondent as a witness, but he wasn't prepared to go to New York to give evidence. So they obtained an order from the Arbitration Tribunal in New York, which gave them permission to make an application to the English court to compel his testimony. So they then applied to the commercial court for an order under section 44(1) and 2A, as they then provided. And if you look at your copy of the Act and just ignore those words in square bracket in subsection 1, that was how the Act stood. And the judge at first instance, Mr. Justice Foxton, noted the decision of Mr. Justice Moore-Bick in Commerce and Industry Insurance, which was a case in 2002, which was the only previous case to consider expressly section 44(2)A about the taking of evidence from witnesses. And there the applicant had sought an order to compel the evidence of two Lloyd's underwriters, again in an arbitration in New York. And the judge, Mr. Justice Moore-Bick, clearly considered he had jurisdiction to make such an order against a non-party witness. But it's fair to say that, having looked at the case, the contrary doesn't actually seem to have been argued. But he decided in the exercise of his discretion not to make an order. But Mr. Justice Foxton referred to two other decisions first instance, to the effect that the powers under Section 44 couldn't be exercised against a non-party. The first was a decision of Mr. Justice Mayles in Cruz City and Unitech 2014, which concerned an attempt to serve out of the jurisdiction an application for a freezing injunction against non-parties to the arbitration. So it was a sort of attempt to exercise in arbitration the Chabra jurisdiction. The principal question in the case was whether service out against a non-party to an arbitration was possible under CPR 6251C, although in considering that question, Mr. Justice Mayles had to consider whether CPR 6251B, which specifically relates to an order under Section 44, did permit service on a non-party. And he reviewed previous authorities which considered the question whether Section 44 permitted orders against non-parties, noting the views of judges either way, but concluded that the better view was that Section 44 didn't include the power to make an order against a non-party. And the second case was a decision of Sarah Cockrell, QC, sitting as a Deputy High Court judge before she was appointed to the bench in a case called D-Tech Trading Morozov in 2017, which concerned an application for permission to serve out again under CPR 6251B in respect of an application for production of a document against a non-party under Section 44.2b, which deals with the preservation of evidence. She considered arguments that the conclusion of Mr. Justice Mayles in Cruz City was wrong, but having essentially relied on the terms of the other subsections in Section 44 and the various authorities, she concluded that whilst there was plainly an argument as to the issue, the correct answer was the one which Mayles J had reached. In A and C, Mr. Justice Foxon, at first instance, particularly influenced by those two decisions, and reached the conclusion that Section 44 didn't permit orders against a non-party. That was reversed by us in the Court of Appeal, in which both Lord Justice Mayles and I gave reasoned judgments, with Lord Justice Newey agreeing with both of us. We only decided the narrow issue, whether Section 44.2a applies to non-parties, not the wider question whether the other heads of the subsection also apply to non-parties, thus leaving for consideration in another case in which the issue arose directly, the question of whether Cruz City and D-Tech were correctly decided. And we were firmly of the view that whatever the position under the other heads of the subsection, Section 42A did extend to non-parties. And we said that for a number of reasons. Firstly, it was clear from the various provisions of the Act, including Section 2.3, which I referred to, that the English court has the same powers in relation to arbitrations wherever their seat as it has in relation to civil proceedings before the High Court. And there was no justification for the argument that the subsection was limited to domestic arbitrations. Secondly, the words, the taking of evidence of witnesses, were apt as a matter of language to cover all witnesses, not just parties to the arbitration. Indeed, in a modern corporate context, it would be relatively rare for a party to an arbitration also to be a witness. Thirdly, the powers which the court has in relation to taking of evidence from witnesses in civil proceedings include the power to order evidence to be given by deposition under CPR 34.8. Limitations on the power the English court would have in relation to the taking of evidence from witnesses for the purpose of foreign court proceedings under the Evidence Proceedings in Other Jurisdictions Act 1975, we said were nothing to the point. And then fourthly, that subsections 1 and 4, subsection 4 of Section 44, as it then stood, provided thresholds or gateways in the case of subsection 4, that an application was made with the permission of the tribunal or the agreement of the parties, which have to be satisfied before the court will exercise the powers. But once they're satisfied, there's nothing in the remainder of the section to restrict the power of the court to make whatever order in relation to the taking of evidence from witnesses it could have made in civil proceedings. And that included the power to order evidence to be taken by deposition. And just pausing there, I think that aspect of our decision is probably quite an important one for the future, because that demonstrates that if you get through the thresholds of subsection 1 and subsection 4, as they now stand, the powers which are given to the court are effectively at large. The court has the same power as it would have in civil proceedings. The other reasons for the order, but perhaps isn't really necessary to deal with those were sort of detailed issues to do with that particular case. But what happened in that case was that the parties agreed, if the Court of Appeal was minded to grant the appeal, which we were, the order which should be made was that the third respondent's evidence should be given before an examiner of the court in London and videotaped, so it was available to the tribunal in New York. And from recollection, I think anecdotally, I was told that, in fact, the evidence was never taken because the pandemic and the lockdowns intervened. I can't remember what happened. I think the arbitration was settled in the end. I think my recollection is all slightly shambolic, which things were, if those of you can remember 5.5 years ago. And the obvious question which ANC left open was whether the other powers under Section 44(2) could be exercised against a non-party. That is an issue, of course, which it isn't necessary to wait for a suitable appeal, as we thought was the case in ANC, because under Section 9 of the 2025 Arbitration Act, Section 44 has been amended in the way in which you see it on your handout, and the powers can generally be exercised in respect of third parties. That amendment, as I said a while ago, followed a recommendation by the Law Commission in its final report on the Arbitration Act. And it recorded paragraph 723 that during the consultation process, it was the view of the judges of the business and property courts that the section should be amended to permit expressly the making of orders against non-parties in view of the confusion in the authorities. And for what it's worth, my own view was that the reasoning in Cruise City and DTEC couldn't, which is essentially based, as I said, on an analysis of the other subsections of Section 44, couldn't really have stood in the light of the decision of the Court of Appeal, although we only decided it on a narrow basis. Because logically, if Mr. Justice Mayles and Sarah Cockrell were right, the appeal in ANC shouldn't have been allowed. Although the actual decisions refusing relief in Cruise City and DTEC may have been correct. But as I said, the enactment of Section 9 really makes that debate academic. There's only been one case, as far as I'm aware, which has considered the amended version of Section 44. And that's a decision of Mr. Justice Calver in a case called VXJ and FY, 2025 EWHC 2394 in September, as I say. That was really a case where the applicants were trying to use Section 43 and Section 44 to obtain third-party disclosure of documents from non-parties. It was a pretty optimistic application, to be honest. And the judge refused the application, essentially on the grounds that the requests for disclosure were too broad and unspecific, and that some of the documentation sought was privileged. Reliance on Section 44 was very much a second string to the applicant's bow. And they relied on 44(2)(c), which provides for the making of orders in relation to property, which is the subject matter of the proceedings, and provides essentially for matters including inspection, photographing, preservation, custody, and detention of the property. And the argument was that the documents which they'd unsuccessfully sought disclosure were property as to which a question arose in the proceedings, and that they were entitled to photograph the property. And the judge rejected that, saying that in view of his findings in respect of Section 44, the application under 43, the application under 44(2)(c) must fail, since he said the documentary requests are more in the nature of an application for disclosure by a non-party, not sufficiently precise, not being shown to be relevant and necessary for the fair disposal of the issues in the arbitration. So what can only be described as a bit of a try-on, frankly. But it does seem to me that what that case demonstrates is that although the powers given under Section 44 as amended are now wide enough to encompass orders against non-parties, they won't be stretched to encompass disclosure by a non-party as such. Section 43 provides for the court to make orders for the attendance of witnesses before the tribunal and for witnesses to be required to produce documents But section 43(4) provides the person shall not be compelled by virtue of this section to produce any document or other material evidence which he could not be compelled to produce in legal proceedings. And Mr. Justice Calver confirmed that that did not mean that a non-party could be required to give disclosure, and followed earlier authorities to that effect, including the decision of Mr. Justice Gross in South Tyneside Borough Council in 2004, who said that a witness summons must specifically identify the documents to be produced, must not be used as an instrument to obtain disclosure. And that's an approach which was approved by the Court of Appeal in Tajik Aluminium. And I suspect that although the new Act has amended section 44 and permits orders against non-parties, the circumstances in which such orders will be made will be comparatively rare, although it's undoubtedly opened up the possibility of the exercise of the Chabra jurisdiction in relation to freezing orders in arbitration cases. And that's a topic on which Michael is going to tell us a bit more in due course. If there are any questions, they'll come later, I think.
Thank you, Julian. So it sounds as though, although the argument in A&C would fall away now in light of the amendment, it's still a relevant authority in terms of the application of the Act plus amendment. Yes, thank you. So Alice, turning to you next, we've been discussing the amendment to subsection 1 to add reference to third parties. But as I mentioned earlier, another one of the changes brought about by the Act is the recognition of emergency arbitrators. So turning to that now, and perhaps to the other side of the coin, we've heard a little about the courts in action. Now thinking about the arbitral side of the coin and whether the tribunal can act. I wondered, can you help us with whether the recognition of emergency arbitrators will make a difference and perhaps keep urgent matters out of section 44 and put them before tribunals instead?
Yes, thank you. Well, as you noted earlier, emergency arbitration is a relatively recent phenomenon. It wasn't until the 2010s that most major institutional or arbitral institutions started introducing emergency arbitrator rules. And before then, a party that needed urgent relief before the tribunal was constituted had to apply to the court under section 44. I think the short answer to your question is that the changes to the Act that now recognise the existence of emergency arbitrators won't make a significant difference to the number of applications coming before the court. And perhaps more broadly, the fact that emergency arbitration now exists also doesn't mean that the role of the court under section 44 is going to fall away. I think inevitably that by dealing with some applications that previously had to be dealt with by the court, emergency arbitration regimes will be taking some of those applications. But even in the era of emergency arbitration, there's still a significant role for the courts. And that's because there are various contexts in which an order of an emergency arbitrator won't effectively meet the needs of a party that seeks urgent interim relief. But to unpack this answer, I think it's helpful to discuss two questions. First, what is the relationship between emergency arbitration and section 44 of the Act? And secondly, in what circumstances will a party want to, and in what circumstances will they be able to, obtain interim relief from the court rather than from the emergency arbitrator? So turning to the first question, the relationship between section 44 and emergency arbitration depends both on the arbitration agreement and on the relevant statutory provisions. With respect to the arbitration agreement, most emergency arbitrator regimes expressly confirm that emergency arbitration rules are not intended to prevent parties from applying for relief before national courts. And it's also well established that clear words are required for an arbitration agreement to exclude section 44. So the starting point will normally be that a party has a choice whether to apply for emergency arbitration or for a section 44 order. The key statutory provision that regulates the relationship between section 44 and emergency arbitration is really subsection 5 of section 44. And in short, sort of paraphrase, this provision provides that the court can only make an order if the tribunal or arbitrator or arbitral institution has no power or is unable for the time being to act effectively. Previously, this made no reference to emergency arbitrator, and now obviously it does. As the Law Commission acknowledged in its reports, there has been considerable uncertainty about what subsection 5 means in circumstances where the parties' arbitration agreement includes emergency arbitration provisions. And this uncertainty revolved around the judgment of Justice Leggett, as he then was, in the 2016 case of Gerald Metals and Timmis. And that judgment contained some comments that were widely interpreted in the arbitration community to mean that the availability of emergency arbitrator rules automatically precludes an application under Section 44. In other words, where it is open to a party to apply for emergency arbitration, this necessarily means that an arbitrator or arbitral institution does not or does have the power to act effectively, such that the condition in subsection 5 will not be satisfied. And according to the consultation responses received by the Law Commission, this interpretation of Gerald Metals was so widespread that some arbitration users were opting out of emergency arbitration provisions for fear that those provisions would prevent the parties from being able to apply to the court under Section 44. So this sort of misconception about Gerald Metals was a concern of the Law Commission, and the Law Commission in its reports made clear that this was actually a misinterpretation of the Gerald Metals decision. In fact, Justice Leggett had merely confirmed the orthodox position, which is that the key question is whether the emergency arbitrator would be able to grant effective relief in the relevant timescale. Justice Leggett expressly acknowledged that the applicable emergency arbitration provisions might be insufficient, for instance, where an application needs to be made without notice to the other party. The Commission actually considered repealing subsection 5 in order to dispel the misconception arising out of Gerald Metals. Ultimately, it concluded that no specific changes to the Act were necessary to clear up the misunderstanding. But as noted, the words emergency arbitrator have been inserted into subsection 5. And I think this does effectively deal with any possible misconception that the availability of an emergency arbitrator regime in and of itself precludes a Section 44 application. Ultimately, the Commission recommended only 2 major changes to the Arbitration Act to kind of recognize the existence of emergency arbitration and to support emergency arbitration. The first change was that Section 41A was inserted. So that's not on this piece of paper, but Section 41A was a new section which empowers emergency arbitrators to issue peremptory orders. So if those orders are ignored, they can be enforced by the court under Section 42. As I'll explain shortly, I don't think this is going to make a significant difference to the number of urgent applications being made in emergency arbitration. The second main change in the Act is that in Section 44(4), emergency arbitrators are now empowered to give parties permission to make a Section 44 application in non-urgent cases. It's perhaps difficult to imagine the circumstances in which a party would apply to an emergency arbitrator for permission to seek non-urgent relief from the court. But the Commission appeared to think it was best to sort of cover all bases and expressly give emergency arbitrators this power. So moving on to the next question, that's sort of the relationship between emergency arbitration and Section 44. But what are the circumstances in which an emergency arbitrator will be unable to act effectively such that a party will want to make a Section 44 application and will be able to do so under Section 44(5)? First, as already touched on, if the application needs to be made ex parte, for example, because there's a risk of dissipation of assets, then Section 44 is generally the only option. And that's because most arbitral rules expressly require notice to be given to the respondent in emergency proceedings. Second, where there's an imminent risk that assets will be dissipated or evidence will be destroyed, the applicant's going to need the court's coercive powers to be immediately available. They'll need an order with a penal notice straight away. And so in those cases, the fact that an emergency arbitrator can now make a peremptory order under Section 41A doesn't really assist, because by the time the arbitrator's initial order has been ignored, it will be too late. Thirdly, and more generally, if the circumstances are extremely urgent, the emergency arbitrator may just not be able to render the award quickly enough or the order rather, quickly enough. The LCIA rules, for example, allow the emergency arbitrator up to 14 days following their appointment to decide the claim for emergency relief. Similarly, the ICC rules allow 15 days. By contrast, court hearings can sometimes be held within a matter of hours rather than days. Fourthly, since the tribunal's powers are limited to the parties to the arbitration, Section 44(5) will likely be satisfied where the order needs to be effective against a non-party. So, for instance, in the case of Pacific Maritime Asia Limited and Hollystone Overseas Limited in 2007, Justice Christopher Clark held that the arbitrator lacked the power to act effectively in relation to the preservation of assets, namely a vessel. And the judge observed that if the order was only that of an arbitrator rather than a court, the harbour authorities where the vessel was located would feel unable to prevent the departure of the vessel. So that case didn't concern emergency arbitrator, but obviously the same reasoning applies. Finally, a Section 44 order will arguably be necessary if an order of the emergency arbitrator would not be enforceable in a target jurisdiction. In many jurisdictions, there is still significant uncertainty as to whether orders of emergency arbitrators are enforceable. So this is a factor that an applicant under Section 44 may well wish to rely upon when showing that it satisfies subsection 5. One might assume that the unenforceability of an arbitral order would be a classic example of a situation where an arbitrator is unable to act effectively. But there's actually authority that casts doubt on this position. In the 2007 case of the Alexandros T, Justice Cook, as he then was, held that the fact that the tribunal's order would not be enforceable in China did not mean that the tribunal was unable to act effectively for the purposes of Section 44(5). At paragraph 108, he stated that the tribunal would be able to act effectively within the meaning of the section, even if their award was ineffective in a particular jurisdiction, because the courts of that jurisdiction refused to recognize its validity or applicability. So Justice Cook therefore drew a distinction between the tribunal's ability to act effectively and the effectiveness of any award rendered. By contrast, it seems that most commentators appear to assume that a party's inability to enforce an order of an emergency arbitrator in a target jurisdiction would be a factor that weighs in favor of the court exercising its discretion to make an order under Section 44. And arguably, this is consistent with the sort of purpose of interpretation of Section 44(5). So that's an issue to watch out for, to see how the courts deal with that issue. And with that, I'll hand it back to Rebecca.
Well, thank you, Alice. So, Michael, looking over to you now, emergency arbitrators notwithstanding, the classic example of an application under Section 44 is probably one for a freezing injunction. Certainly the application I've made myself most under this section. Will that remain true with the changes to the Act? And are there any special considerations when you apply under the new regime for a freezing injunction?
Thanks, Rebecca. I think the answer to your first question is undoubtedly yes, essentially for the reasons that Alice has developed. The Section 44 jurisdiction is undoubtedly the first port of call for an applicant in search of a freezing order, because, as Alice has touched upon, it's only the court that can make an order endorsed with a penal notice, service of which will engage the court's contempt jurisdiction in the event that it is breached, leading to imprisonment, fines, and sequestration of assets. And that's the case even with the new developments in emergency arbitrator provisions. And so under subsection 5 of Section 44, where freezing relief is required, you are going to be within that gateway. I think there's 3 points I'd highlight with respect to practice under Section 44, including as amended. The first is, it follows on from a point that Sir Julian made at the outset, which is that Section 44 grants the court jurisdiction not only in respect of domestic London-seated arbitrations, but also in respect of foreign arbitrations. But there is an important difference to the court's approach to granting freezing relief between those two situations. For London arbitrations, one can expect broadly the same approach to be taken by the court under Section 44 as it would when dealing with freezing relief in court proceedings. So If you can demonstrate that you have a good arguable case on the merits in the arbitration, there is solid evidence of a risk of dissipation, and it is just and convenient otherwise to grant the relief, you are very likely to be granted a freezing order by the court under Section 44. That is in contrast, I should say, including on a worldwide basis. But that is in contrast to where the application for freezing relief is made in support of a foreign-seated arbitration. Now, in that situation, the English court is not the supervisory court of the arbitration, and it will be more circumspect in granting relief. Although Sir Julian mentioned Section 2 of the Act simply says that the court has jurisdiction, save that it won't exercise it where it's not appropriate to do so, the recent cases under the Act make clear that the court is concerned about comity in that situation, where it is not the supervisory court. And absent a link to the English jurisdiction, such as property belonging to the respondent within the jurisdiction that can be frozen, it's unlikely to grant freezing relief, particularly worldwide freezing relief, absent exceptional circumstances justifying that course. So that's an important difference in practice under Section 44 as opposed to court proceedings, which remains under the amended Act. The second point on practice that I'd highlight is that Section 44 contains a trap for the unwary when it comes to the continuation of a freezing order granted on a without notice basis. Now, as Alice has touched upon, where an applicant seeks freezing relief from the court, it will invariably apply on an urgent and without notice basis to avoid tipping off the respondent and prompting dissipation of assets. And Section 44 allows you to make such an application because, as you will see in subsection 3, which remains in the Act, that subsection provides that if the case is one of urgency, the court may, on the application of a party to the arbitral proceedings, make such orders as it thinks necessary for the purposes of preserving evidence or assets. So that gives you the gateway into a without notice application to the court when you need freezing relief. But once the applicant has obtained a without notice freezing injunction, the court will, in the usual course, list a return date and require the applicant to apply for the injunction to be continued on an inter partes basis. However, the urgency provision in subsection 3 of Section 44 does not cover the continuation application where there is a constituted arbitral tribunal, which in most cases there will be, because even if you have applied prior to the arbitration being constituted, the court will require as an undertaking the immediate constitution of the arbitral proceedings. Now, that point about jurisdiction was made clear in a fairly recent case called VTB Commodities and Antipinski Refinery, where the commercial court held, having granted the ex parte order, it did not retain jurisdiction to deal with the continuation application once the matter had ceased to be urgent on an inter partes basis. Jurisdiction returns to the tribunal. Now, of course, you obviously want the court to continue the freezing order because you want the continuation order endorsed with a penal notice for the reasons that I've just touched upon. But that means that once one has obtained the without notice freezing order, it is essential to get the permission of the tribunal for the continuation of the application to be dealt with by the court under subsection 4 of the Act. So on the continuation, you've moved from subsection 3 to subsection 4, and the consent of the tribunal is essential. And the third point to make is actually what I expect to be an alignment between the availability of freezing relief in support of arbitration and court proceedings. And Sir Julian has foreshadowed this. And I'm referring to the new availability of freezing relief on the Shabra basis in support of arbitrations. And the Shabra jurisdiction enables the court to freeze assets not only of the respondent, but also of third parties against whom the claimant will ultimately be able to enforce any judgment or award obtained against the respondent. And usually that sort of relief is justified on the basis that the Shabra defendant is effectively controlled by the respondent and is merely holding assets for that respondent, usually in an attempt to prevent effective enforcement of any judgment or award. And so, as Sir Julian mentioned, until recently, that type of relief has faced the insuperable bar of the decision of the Commercial Court in Cruise City and Unitech, where Mr. Justice Mayles held there was no such jurisdiction to grant such relief on the basis that the relevant provision of Section 44 of the Act did not apply against third parties. But as and that of course precluded any type of Shabra relief. But as Sir Julian has explained, the amendment to the Act, which you can see in the square brackets in subsection 1, just the insertion of those short words has effectively resulted in the statutory reversal of the effect of Cruise City. And that, I think, as Sir Julian has also mentioned, I think is pretty clear from the Law Commission's report. The Commission has expressly referenced the decision in Cruise City and referred to a number of other responses in addition to the judges from the Business and Property Court, where the view was expressed by a large majority of respondents that this was an unsatisfactory position. So effectively, there is now no jurisdictional bar to the grant of Shabra relief in support of arbitral proceedings. But of course, just because the court has jurisdiction does not mean that it will invariably exercise it. Each application will turn on its own facts. And I think we can expect the court, when exercising its Section 44 powers, including on a Shabra basis, to be mindful of the fact that it is still acting in its capacity as a supervisory court that is not seized of the merits of the dispute. But nonetheless, I think we can now expect a substantial alignment of the practice in relation to Shabra relief as between English litigation and London arbitrations. And just returning to the first point I made in this respect, where one is dealing with Section 44 relief in support of London-seated arbitrations, generally one expects the court to take a similar approach as it does in court proceedings, because the court is cognizant of the fact that only it can grant the effective relief. So it's not in any way stepping on the toes of the arbitral tribunal. But again, I think when it comes to foreign arbitrations, we can still expect that concern about comity to apply when relief is sought on a Shabra basis as well. And we probably still are looking at an exceptional circumstances test, particularly if one is seeking to freeze the assets of Shabra defendants outside the jurisdiction. So that's where we are with freezing orders.
Thank you, Michael. I sensed some nodding as you spoke then from my right. Julian, you and I recently participated in a seminar about freezing injunctions, and the mood of the meeting was very much that the court needs to be careful about exercising these extended powers. Would you like to comment on what Michael's just been saying?
Only to this extent. I mean, I entirely agree with him. I think that so far as English-seated arbitration is concerned, I think the effect of the amendment to subsection 1, so that orders can be made against non-parties, is amongst other things intended to permit the Shabra jurisdiction to be exercised. And effectively, I mean, there's no case yet, but I suspect that it means that Cruise City will not be followed in future. And that's certainly what the Law Commission intended, and what most of the responses to the Law Commission consultation were to that effect. I think where it's a foreign seated arbitration position is much more difficult, and really, sort of thinking about it, I think it's only really going to be in cases of the sort of huge international fraud type cases. If the dispute is in arbitration in, say, New York, and there are assets in this jurisdiction which are basically being shuffled around by the respondent and placing the assets with other corporate entities, the sort of Shabra situation, I can see that an English court might, in those circumstances, be prepared to make a freezing order if the New York courts couldn't. But otherwise, I think the English court is likely to be circumspect and saying to itself, we really ought not to act in the situation where the relevant arbitration is being conducted under the supervision of another jurisdiction in terms of court jurisdiction, and what orders should be made in support of that arbitration, really for the foreign court and not for the English court. I think that I'm not aware of any case where the English court has made an order in respect of a foreign arbitration, which is an order which couldn't be made in the relevant foreign jurisdiction, because there's obviously a comity issue there.
Thank you. So there's maybe an area to watch. But thank you for that. No, Andrew, we've been talking about freezing injunctions, but when we look at subsection 2, there's a long list of matters in relation to which the court may make orders under section 44. So should we all be more imaginative and using section 44 more widely?
I don't think the answer is that we need to be more imaginative. These powers are rarely used because the situations in which they really, really help are quite narrow. But those situations do arise, and when they arise, nothing else will do. There are 3 powers that haven't really been touched on so far because they're the unusual ones. If you have a look at your sheet of paper, which I hope you all have, you can see preservation of evidence and then property under section 44, 2B and C, sale of goods under section 44, 2D, and then towards the end of 44, 2E, appointment of a receiver. Now, the first of those, preservation of evidence and property, I think has become rarer and rarer. It was fairly rare to begin with, and that's because tribunals have closely analogous powers under sections 38.4 and 38.6 of the Act. They can order inspection, photographing, preservation, and so on. I think it's becoming rarer because, as Alice was saying, emergency arbitrators sometimes deal with situations that used to force parties to come to the court before a tribunal had been or could be put in place. But tribunals have got limits. They can only give directions to the parties. They can't bind third parties, and the court can. And that's the narrow gap where section 44 2B, preservation of evidence and property, still seems to me to be quite important. Now, I wonder whether we might see more use of this provision now that the amendment to section 44.1 makes it crystal clear that the court's powers can be exercised against a third party. Now, one example that I found, the only example that I found, predates the amendment, and it's a case called Assamina Maritime, 2004. What happened in that one is that a vessel grounded off Karachi, and there was a dispute about whether or not that was a safe port. A British survey firm had produced a report on the channel leading to the port for the Karachi Port Trust. And the tribunal obviously had no jurisdiction over that third-party survey firm. So what happened is that the owners of the vessel applied under section 44.2 of the Act for the report. And the court said, and Sir Julian touched on this, that section 44 doesn't permit a general third-party disclosure order, but what it does allow for is an order requiring the production of a specific and identifiable document. Both bases were proceeded on in this case, 44.2 and 44.3, and the order was made. And so that is an example, the example that I found of this one being used in a third-party situation. But you can imagine similar applications in other circumstances. For example, although no reported case in these terms exists so far as I've been able to tell, you can imagine that a disgruntled buyer of a company might want to get access to an aborted audit report to see what was known about what was going on with the company before the purchase. And we'll just have to see how the law develops here now that the change to section 44.1 has made it a little bit clearer. The second power that I want to talk about is the power of sale of goods that are the subject of proceedings under 44.2D. Now, this is another very unusual one. the tribunal hasn't got an equivalent power, only the court can do it, and it is rarely used. So far as reported cases go, I think it's confined to shipping disputes. And to take one example, the MV Lord Hassan 2024, in that case, a cargo of corn was shipped under a freight prepaid bill of lading, but the freight hadn't actually been prepaid, and the owners of the vessel kept hold of the bill of lading. They exercised a lien over the cargo, and they stuck it in a warehouse. Now, the cargo was deteriorating, and so the owners wanted to get it off their hands, turn it into money, and they applied for an order for sale. And that was granted so that the parties to the arbitration could argue about the money, which would effectively stay as money, rather than about a cargo of corn which was rapidly going mouldy and getting infested with maggots. Now, in the right case, it's hard to think of a cleaner and more practical remedy than that. It cuts through standoffs about what to do with goods that are wasting, deteriorating, or incurring demurrage charges, for instance. And it is possible, I think, to imagine this being used outside of a shipping context. Imagine, again, a joint venture. A joint venture has collapsed. JV sits on a large stock of inventory, consumer goods, components, something like that, and the stock is becoming obsolete and it's expensive to store. If neither party wants to deal with it, then you end up with a deadlock, and a sale order can break that deadlock, allowing the proceeds to be held while the tribunal decides the rights and wrongs of the dispute. And again, and this may be one where we see an expansion, goods affected by sanctions. Given the current sanctions landscape, there might be more of that coming around the corner. The third power, and the last power that I wanted to speak about here, is receivership under section 44(2)(e). Now, that's also not a power that the tribunal has, at least by default. In principle, the parties could authorize the tribunal to appoint a receiver, and that's to say a third party who can manage assets that are the subject of proceedings, but the receiver would need supervision by the court. So as a practical matter, this is a court-driven remedy. There's only one reported case of this, again, that I've been able to find in the arbitration context, and that's Deutsche Bank and Central Bank of Venezuela 2023. What happened in that one is that the Central Bank of Venezuela had entered into some bullion swap contracts, I think they were, and the Central Bank of Venezuela said, well, we'd like the money back, please. And the problem was that there were two separate political entities which said they controlled the Central Bank of Venezuela. There was the Guaido board and there was the Maduro board. And this has given rise to other disputes. Essentially, Deutsche Bank wanted to close these trades out and just wash its hands of all of this. And so an order was applied for under Section 44, and the swaps were closed out and the proceeds were held then by a receiver, while the Guaido board and the Maduro board scrapped it out about who was entitled to have the proceeds. Now, oddly, the initial decision isn't reported. We only know about it because there was a later scrap about the receiver's remuneration, but we know it has been done. Now, receivership matters in cases where a sale isn't appropriate. There are some assets that have got to be managed rather than liquidated. Again, I think this could come up in a joint venture context when the relationship has broken down. If you've got a business that's actually making money, you want it to keep running. But if neither party trusts the other, then you have a very real problem. And a receiver is one way of solving that problem. It can preserve the business as a going concern while the arbitration continues. And I think it's perhaps surprising that we've only got one reported case using this power. In the right case, I think it might be the only practical answer. So if the question is, should we all be using Section 44 widely? I think the answer is probably not really. But when the situations which those powers cover arise, they solve problems that the tribunals simply can't reach. They're useful tools, and I think we just need to remember sometimes that they're there.
Thank you. I think that's a yes, really, to should we be more imaginative when questions arise. So that's enough from us. There's time for some questions. Would anyone like to ask the panel a question about section 44? Well, let me turn it round. Has anyone had practical experience of using section 44 in a way that we've not covered? Thank you. I'm just going to pass you the microphone so that those online can hear you.
Good morning, I'm Duncan Bagshaw. I'm from Norton Rose Fulbright. One area that interests me is that institutions are introducing powers for tribunals to make an emergency arbitrator to make an order without notice to the respondent. The SIAC has already done it in Singapore, and it's being considered by other institutions. And that creates a really tricky situation to navigate, where the court may well be asked to intervene, or the party may want the court to intervene before any notice is given of the emergency arbitrator's order to the party who is the subject of it. But the structure of the Act seems to me to make that impossible, because generally speaking, the court will only enforce an emergency arbitrator's order once the person subject to the order has failed to comply with it. I was just wondering whether anybody had thought about that development in institutional rules, and whether it's going to create an impossible situation, or whether it's navigable. Thanks.
I haven't specifically thought about that, and I don't think the Law Commission did either. So I would agree with you that at this point it's pretty hard to see how that's going to work. And yes, how that works alongside Section 41A. And maybe further amendments are going to be necessary to actually accommodate that, because I think the changes were certainly made on the assumption that that the emergency arbitrator orders are made on notice.
I think one of the issues is the issue about penal notices and the like, because I think it's one of the points that you made, that the reason why people will go to court to get an order is because they will get an order that's got some bite to it. The non-compliance which will be a contempt of court. I think in the context of emergency arbitration or emergency arbitrators, that's much more problematic. I don't think any of the institutions could confer on the arbitrator, the emergency arbitrator, any sort of power, any sort of penal power. So I think that, but I mean, I take your point. I mean, goodness me, God help the judge who has to deal with a situation where he's faced with an application on the one hand to the court, and on the other hand, the argument that in fact an application could have been made to an emergency arbitrator who would have had the same power. As Alice says, possibly something the Law Commission didn't really think about.
Yeah, one can't help feeling that distinction between ability to act and whether the action is effective is a pretty difficult one to maintain. And hearing you speak, Alice, I was thinking there might be some more litigation about that to come. It sounds a very uneasy tension.
Well, the Alexandros T is.
Yes.
Let's just say a slightly difficult decision, I think.
No, thank you. That's a very interesting question, and does illustrate what a fluid picture we have. And this is a new act, but the problems aren't all solved in it, that's for sure. Perhaps that's good news for us all as lawyers. Good. Any more questions? No? Well, thank you very much to the panelists for their contribution, and thank you all for coming. There is a lot of breakfast left, so please join us for a chat and another bacon roll. Thank you all.